This is a story about a board that assumed their power had no limits, and an African-American homeowner who didn't just get mad.
Imagine waking up, looking out your window, and seeing heavy machinery dropping massive shipping containers onto your front lawn. Now imagine your homeowners association telling you that you just have to deal with it. This is a story about a board that assumed their power had no limits, and a homeowner who didn't just get mad. He got even. By turning his yard into a commercial storage facility, he legally trapped the HOA in a debt so large, a judge eventually handed him the keys to everything they owned. Let's dive into how it happened. Our story centers around a homeowner we'll call Alex. Alex lived in a quiet suburban community, specifically chosen because his house sat on a sprawling corner lot. The edge of his property was bordered by a thick line of mature pine trees, giving him a sense of privacy that is rare in modern developments. For years, Alex enjoyed a peaceful existence. He paid his dues, kept his lawn immaculate, and mostly ignored the neighborhood politics. But as many homeowners know, peace in a managed community only lasts until the board decides it's time for a change. The shift started when a newly elected HOA board took power. They were eager to leave their mark and quickly announced a massive $500,000 renovation of the community clubhouse. It was a project that required tearing out the old interior, storing materials, and staging heavy equipment. It was ambitious, perhaps too ambitious. What the board completely failed to plan for was the sheer logistics of the operation. They had ordered mountains of materials, but had absolutely zero space on the actual clubhouse grounds to store them. Alex's first hint of trouble came on a Tuesday afternoon. Driving home from work, he heard the unmistakable roar of diesel engines. As he pulled into his driveway, he was met with a bizarre sight. A flatbed truck was just pulling away, leaving behind 3 massive, rusted corrugated steel shipping containers. They were sitting right on the grassy edge of his property, just in front of his beloved pine trees. There was no warning, no email, and no phone call. Just tons of steel dumped onto his private land. Furious, Alex immediately called the HOA president, a man who treated his volunteer position like a supreme dictatorship. The president was totally dismissive. "Relax, Alex," he sighed over the phone. "That strip of land is a utility easement. We have every right to use it for community improvements. It's temporary, just bear with it for the good of the neighborhood." He hung up before Alex could argue. But here is what many homeowners don't realize. HOA boards frequently misuse the term easement to justify overstepping their legal boundaries. If Alex thought 3 containers were an eyesore, he was in for a rude awakening. Over the next week, the invasion multiplied. Day by day, more trucks arrived. 3 containers turned into 6, then 10, and finally, a staggering 14 shipping containers formed a literal fortress of steel on the edge of his property. Adding insult to injury, contractors were arriving at 6 a.m. every morning, slamming the heavy metal doors, shouting, and tossing materials around just yards away from Alex's bedroom window. Alex knew he needed undeniable proof before taking his next step. He hired an independent, licensed land surveyor to come out and mark the exact boundaries of his lot. It's a vital step in any property dispute. The surveyor drove bright wooden stakes into the ground, running a neon pink string line straight through the mud. The results were indisputable. There was no community easement. The HOA had dropped 14 massive shipping containers a full 20 feet inside Alex's private, deeded property line. Armed with the survey, Alex retained a real estate attorney. They drafted a firm cease and desist letter, attaching the official survey documents. The letter was clear. The HOA was illegally trespassing on private property. They were given exactly 14 days to hire cranes, remove the containers, and restore the damaged grass to its original condition, or face immediate legal action. It was a standard professional warning, the kind that would make any rational organization immediately correct their mistake. But this board was far from rational. The 14 days came and went without a single container being moved. In fact, the HOA president actively ignored the letter, telling neighbors that Alex was just being a roadblock to community progress. Meanwhile, the heavy boots of contractors and the tires of pickup trucks continued to completely obliterate Alex's lawn, turning a lush green space into a rutted, muddy construction yard. The board thought Alex would eventually just give up and accept it. Seeing that the HOA was calling his bluff, Alex's lawyer proposed a brilliant pivot. If the HOA absolutely insisted on using Alex's land to store their property, then Alex was well within his rights to treat them like a tenant. Under the law in many jurisdictions, if someone leaves property on your land after being formally told to remove it, you can establish an implied storage agreement. The lawyer advised Alex to draft a commercial lease, turning his hijacked lawn into a very expensive, very legal storage facility. They researched local commercial storage rates for units of that size. They settled on a very fair market rate price of $300 per container, per month. With 14 containers, the HOA was now racking up a bill of $4,200 every single month. Alex printed the invoices, attached the terms of the storage agreement, and sent them to the HOA board via certified mail. Certified mail is crucial here, as it provides a legal paper trail proving that the board received the bills and the terms. Months dragged on. The clubhouse renovation was plagued by delays, meaning the containers sat entirely undisturbed on Alex's property. Every month, like clockwork, Alex mailed a new invoice. Every month, the board threw it in the trash. By the 6-month mark, with late fees and penalties outlined in the lease agreement, the HOA owed Alex over $25,000 in storage fees. The board president was heard laughing about it at a community meeting, calling the invoices fake bills from a crazy neighbor. At the 8-month mark, Alex finally dropped the hammer. He and his attorney filed a formal civil lawsuit against the Homeowners Association. The lawsuit cited trespassing, destruction of private property, and breach of the implied commercial lease, seeking over $30,000 in unpaid rent. When the process server handed the lawsuit to the HOA president, the laughing finally stopped. But true to form, the board refused to settle, insisting that a judge would recognize their supreme authority over the neighborhood aesthetics. The day of the trial arrived. The courtroom was tense. The HOA president took the stand, exuding an unearned confidence. He testified that the association had an inherent right to utilize neighborhood space for the greater good of the community, and framed Alex as a selfish resident trying to extort the neighborhood. He spoke as if the HOA's bylaws somehow superseded the foundational laws of private property ownership. It was a bold strategy, and one that the judge was not having. The judge stopped the president mid-sentence. He looked down at the surveyor's report, then peered over his glasses at the HOA's legal counsel. "Counsel," the judge said, "please produce the signed contract where this homeowner agreed to surrender his private land for your construction staging." The lawyer shuffled his papers, nervously admitting no such document existed. The judge's demeanor turned icy. He chastised the board for their blatant arrogance and their fundamental misunderstanding of property lines. The ruling was swift and devastating for the board. The judge validated the property survey and upheld the legality of Alex's commercial invoices. Because the HOA was formally notified and chose to leave the containers there anyway, they had implicitly accepted the storage terms. The judge ordered the HOA to pay Alex the full $33,000 in accumulated rent, plus another $5,000 to cover the damages to his landscaping, and entirely cover Alex's legal fees. It was a total victory, but the drama wasn't over. When it came time to collect, the HOA's attorney had to make a humiliating admission to the court. The board had completely mismanaged the clubhouse renovation. They had drained their entire reserve fund paying contractors for delayed work. The HOA's bank accounts were effectively empty. They simply did not have the cash to pay the $38,000 judgment they now owed Alex. The board president looked pale, realizing his stubbornness had bankrupted the association. This is where the legal system provides a fascinating remedy. When a debtor cannot pay a court-ordered judgment in cash, the winner can file for a writ of execution, a legal order allowing the seizure of the debtor's physical assets. Alex's lawyer pointed out that the HOA owned 14 shipping containers sitting right on Alex's property. The judge agreed. In a stunning conclusion, the judge signed an order transferring complete ownership of the containers, and everything inside them, directly to Alex to satisfy the debt. The next day, accompanied by a local sheriff's deputy to keep the peace, Alex walked out to his yard with a pair of heavy-duty bolt cutters. He snapped the padlocks off the doors. Inside, he found a gold mine. The HOA had pre-purchased all the materials for the clubhouse. There were rows of brand-new, commercial-grade treadmills, pallets of imported Italian floor tile, high-end leather lounge furniture, and 2 zero-turn riding mowers. Alex legally owned all of it. Over the next month, he liquidated the inventory, easily covering the debt and making a tidy profit. In the end, the HOA had to completely abandon the clubhouse renovation. The president resigned in disgrace, and the community learned a very expensive lesson about the limits of their power. Property rights are the foundation of homeownership, and no board is above the law. Have you ever had an HOA overstep their boundaries in your neighborhood? Let me know your stories in the comments below, and don't forget to like and subscribe for more deep dives into the wild world of neighborhood drama. This is a work of fiction, shared for illustrative purposes only. It is not legal advice.